Hello and welcome to the 4th Thames Valley AI Hub event, AI and Intellectual Property. My name is Sarah Wirtz and I'm the Business Relationship Manager at the University of Reading, and I'm the Lead Coordinator for the TVAI Hub initiative. Joining me today, as always, are my colleagues Claire and Rowan, who are providing technical support. Claire, Rowan, do you want to say hi and say what your role is with the Hub?
Good afternoon, I'm Claire. Welcome to this event. I'm the Events and Network Manager for the Hub and assist Rowan with the marketing by keeping the LinkedIn page updated with relevant content and information from ourselves and our partners. Please follow us on LinkedIn and Twitter, and don't forget to tag us in any posts that you would like shared with the network. You will receive a feedback form after this event, and it would be helpful if you could fill it in. It will only take you a couple of minutes of your time, and your reports will remain anonymous. Your comments will remain anonymous. Your opinions and suggestions are important to us and will help us shape future activity. Thank you.
Good afternoon, everybody. As Claire said, my name's Rowan and I co-manage the marketing. And I just want to say a very sincere thanks to you all for joining us today. I hope you're all keeping well and I hope you're all keeping safe, but I'm sure you've all heard that a billion times already today, so I'll move swiftly on. We're working really hard and have been for the past 6 months or so to build this network of people in the AI community. So if you have any questions about what we're doing today after the event, please get in touch with us. Sarah's going to share all the contact details, and I hope you enjoy it.
Thanks. Thank you all so much for joining us today. AI is going to transform the practice of law, and I'm really looking forward to listening to our speakers today and finding out more about AI and intellectual property rights and AI policy in the UK. So this is the agenda. So I'm going to start by giving you a bit of information about the Hub and some of the events we've got coming up and how today's going to run. And then, because we're not able to meet face-to-face and network in person, we've arranged to show you 6 short videos from local business support services and SMEs to explain what it is that they do. And hopefully this will give you a bit of a flavour for the type of activity that's going on locally and within the network, and in some small way, recreate those fortuitous chance discussions you have over coffee before the event starts. So after the videos, I'm going to hand over to Adrian Orenson-Stourier, who is a Associate Professor in Law at the University of Reading, and he's going to present on copyright and the creative AI. We should have time for a few questions with him before handing over to Rajeshri Bonjani and Georgia Shriyan, who are the Commercial Technology Partner and the Senior Associate Commercial at Harrison Clark Rickaby Solicitors, and they will talk about IP issues in AI. Again, we'll have a chance to have a few questions for them for opening up to a broader panel discussion where you can ask questions for all of our speakers today. I'll close with some short remarks and then we'll be finished by 6. So the University of Reading established the Thames Valley AI Hub to connect the local AI community together to accelerate innovation. We want to make this region internationally recognised for its expertise in AI, and so we are bringing people together, we're enabling collaboration, and we're trying to develop the pipeline of talent. So one of the big streams of activity we have is our events programme, which we have an extensive programme of events to try and bring people together and try and create that valuable collision space. Our next event is on the 16th of September, which we're co-hosting with Life Hub UK, and this will be a co-hosted event around AI and machine learning in healthcare. We're delighted to be joined by Dr. Jackie Hunter, who is the Chief Executive for Clinical and Strategic Partnerships at Benevolent AI, and also Professor Lana Tesarenko from the University of Oxford, who's also the R&D Director for SenseSign Health. Then a few weeks later, on the 30th of September, we're kicking off our training strand of activity with an event on data science, a new career for you. We're going to hear from Andrew Sivanson, who is a NATS data science specialist, and he's going to talk about his experience and journey in upskilling in data science and hopefully help inspire others to consider data science as a career. He'll be joined by Ella Cockrell, who is a business development leader at Microsoft, and she's also the lead for Microsoft's data science boot camps. These boot camps are free courses for women to teach them digital skills so they can get a job in the technology sector. But Ella will also give an overview of the various online resources which are available to support all aspiring data scientists. Then in October, as part of our funding stream of activity, myself and my colleague Carol McAnally will be doing an event on R&D grant funding, what's available and how to apply. Carol and I have both been involved in the submission of a large number of grants to Innovate UK, and so we want you to benefit from our experience, and we will talk to you about give you some hints and tips about how to make your application as competitive as possible. So in order to sign up to our events, you can do that through our LinkedIn page or our website, and the details of which are shown here. Please do get in touch with us. The Hub is for the community, so we do really want to hear from you. And we also want to be a valuable source of information for our network. As well as highlighting the latest advances in AI, we regularly signpost to business support services and funding opportunities to help you make the most of the opportunities which are available. So do please email us, follow us on Twitter, LinkedIn, and regularly check out the website for content. And if you'd like to tweet today during the event, please use the hashtag TVAI Hub. Okay, so how's today going to work? So for our previous webinars, we've used the platform Zoom webinar, which worked really smoothly, but we did receive some feedback that the attendees would have preferred to be able to see the other people who were present. And so for today, we are trialing just using Zoom. So apologies if there are any technical difficulties. Please note the webinar is being recorded, and please email us if you have any concerns about that. We email our webinars so that they can be made available for those who aren't able to be with us today. And if you go onto our website on the library tab, you'll be able to see a list of all the different webinars that we have. Please do use the chat function for general discussion and to ask any questions. We want to hear from you, as many of you as possible, and for this to be as interactive as possible. And if you would like to ask a question anonymously, if you go into the chat, you'll see that the default setting is to reply to everyone, but you can click on that and select my name, Sarah Wirtz, and then you can message me directly and I can ask the questions on your behalf. Everyone should automatically be on mute, but can you just check that you are, because any background noise can disrupt the webinar. As Claire said, you'll be asked to complete a short questionnaire after the webinar, and this feedback is anonymous. Please complete it if you're able to. We'd really appreciate hearing from you. The Hub is for the community, so we really need to know what you think so we can improve our events and the content that we're providing. I'd be particularly interested to know what you think of the platform we're using today, especially if you've been to some of our previous events. And also what you think about the videos as well, because this is a new thing that we're trialing. If you're experiencing technical difficulties, please email us at tvaihub@reading.ac.uk, and Rowan will endeavour to help you. Also, if you would like to send an email to us if you want us to ask any questions and the chat function's not working, please do that. Okay, so I'm now going to hand over and show you some of these videos.
Hello, I'm Elizabeth from TechNation. TechNation is the growth platform for scaling tech companies and leaders. We connect and enable scaling digital tech founders from all across the UK. My role as Entrepreneur Engagement Manager is to champion the UK tech scale-ups that are right here in the southeast of England. Now, we bring UK-wide founders together who are at a similar stage in their journey so that they can support each other and learn from each other, as well as connecting them with founders who are further along in their scaling journey. Our formal support includes 7 peer-to-peer growth programs, data and insights looking specifically at digital tech within the UK, and we also process the endorsements for the Global Talent Visa. Law Tech is an initiative that's going to transform the UK legal sector through tech. It's delivered through a collaboration between TechNation, the Law Tech Delivery Panel, and the Ministry of Justice. It provides leadership, tools, and a work programme to help the legal and tech community deliver tomorrow's legal services today. The UK has emerged as the hub for startups and scale-ups developing law tech products and services. We class law tech to include technology used by legal service providers or the justice community to help them deliver legal services or resolve disputes. It also includes technology that allows businesses and individuals to take care of their own legal matters. You can find out more by following us on Twitter at lawtech_UK, or also by going to the website you can see on the screen. You can sign up to receive regular updates and also find out how you can get involved and support and collaborate with this project. Thank you very much.
The well-being cost in the UK as we speak is 2.25 billion per day. In the corporate sector, despite such huge investment, the employee well-being programs adopt a one-size-fits-all approach. Instead of burning cash every month on corporate gym memberships, which only a few people use, imagine the impact you can have if you identify every employee's well-being needs and then invest in a personalized program. LittleBox is launching a well-being app, which allows you to spot your team's well-being needs using AI and behavioral algorithms. The app tracks your employees' well-being, creates an action plan, and measures its impact on performance to demonstrate the ROI on your well-being program. This evidence-based app is derived from 15 years of practical research and validation. We are on a mission to bring positivity back to the workplace. So no more monthly deductions from your bank account. Try a app with your team and pay what you think it's worth. After all, happiness is every employee's right.
Hello, I'm Jurek Sikorski, Executive Director of the Henley Centre for Entrepreneurship, a centre that not only conducts research into entrepreneurship, but supports entrepreneurs in their journey to start and build thriving and vibrant businesses. We support entrepreneurs in many ways that includes the business clinics, summer startup bootcamp, business idea competition. We offer incubation space. And what I'd like to tell you more about at this time is the Henley Business Angels, or HBA. HBA is a membership of high net worth individuals and sophisticated investors who are drawn from the University of Reading and Henley Business School alumni communities. HBA's overarching aim is to support early stage high growth businesses through investment and mentorship. HBA functions around quarterly pitch events and has a strong investment record. A total of 202 companies have applied for investment over 15 rounds since HBA was formed. 74 have pitched, 10 have pitched more than once, and 22 have received investments amounting in aggregate to over £1.1 million. For further information about HBA, go to www.henleybusinessangels.com. HBA is here to help. If you are an early stage business and seeking seed finance, then drop me an email at jurek.sikorski@henley.ac.uk or give me a call on 07889 720 735. I look forward to speaking with you. Thank you for listening.
Hi, I'm Duncan Everett, Managing Director of Optimal Monitoring. We've been using AI to revolutionise the field of energy management. Using AI, we've been not only able to significantly improve the process of identifying energy waste, but also by classifying this, we've been able to identify the most likely cause and offer solutions. Using the freely available consumption data from the utility providers, AI creates fault tickets which can be sent directly to the maintenance provider. Your energy manager is then focused on implementation of efficiency rather than investigation. Using AI to profile each fault in conjunction with user feedback, AI learns new reasons and solutions over time. Consequently, Emma's advice is continuously improving through the collective experience of its users. Using this technique, we've made energy efficiency attainable for even small organisations, not just those with very large consumptions. Organisations in the retail sector are experiencing great advantage from the Emma AI process. If you'd like some more information, please feel free to contact us at info@optimalmonitoring.com. Thank you very much.
Hi, I'm Maddie Woodman and I'm the Learning Manager and the Project Manager of the Henley World of Work initiative. What I want to talk to you about today and invite you to is our World of Work WTF What the Fringe Festival that we will be running virtually in September. To give you a little bit of context on Henley World of Work, The World of Work Conference is the annual Future of Work Conference from Henley Business School. And past years, so this is the 4th year that we'll be running it, past years have been so much fun. And we've talked about things like workplaces of the future of money, D&I, virtual reality, things like augmented humans, predicting the future using data. And we've always had things like live music. We had last year AI cupcakes. So we wanted to recreate this kind of vibe in our festival. So this September, the World of Work WTF What the Fringe Festival. The theme is the acceleration of the future of work from COVID-19. So we want to cover subjects such as inequalities, Black Lives Matter, UK BAME coronavirus report, building connections when we are disconnected. So online working, the COVID safe office of the future, using the Internet of Things, and all sorts of stuff like that. And we'd love to see you there. It'd be so interesting. So the details are really easy to remember. It's Tuesday, Wednesday and Thursday, the 8th, 9th and 10th of September. And it will be from 3 to 4:30 p.m. Short and sweet bursts of information, really interesting and interactive. And we will also have live DJ sets as always. So we'd love to see you there. Please go to this link to book and find out more information.
Hi, I'm Natasha Sedgwick. I'm from the Thames Valley Berkshire Business Growth Hub. We provide free business advice and support services to Berkshire-based businesses. Now that includes entrepreneurs, startups, social enterprises, scale-ups, and established businesses up to 250 employees. Whether your business has been knocked off course because of the coronavirus, or you've identified new opportunities and looking to grow, we're here to help. We have a team of business advisors and a network of over 90 partner experts who can provide you with advice for anything from business strategy and planning to social media, sales, marketing, accessing finance, export and intellectual property. There's various ways we can support you. We have online information and advice on our website. We can offer one-to-one advice sessions via email, telephone and video conferencing. We run a number of events all at the moment online, and we have a distinctive program such as the new Recovery and Growth program, where you can access 12 hours of tailored advice and be assigned a business advisor from the Growth Hub to work with your business over a 3 to 4 month program on a recovery or growth strategy. Now, all our services are free, impartial and confidential. We are funded by the Thames Valley Berkshire Local Enterprise Partnership, and our only objective is to help your Berkshire businesses succeed. We're here to help you not just survive the pandemic, but to thrive. So if you want to find out more about how we may be able to help and support you on your business journey, check out the berkshirebusinesshub.co.uk. That's the berkshirebusinesshub.co.uk.
Okay, thank you. Well, I hope you enjoyed those videos. And now it's time for me to hand over to Adrian and his presentation. Thank you, Adrian.
Hi everyone, my name is Adrian Aronson-Storia and I'm an Associate Professor at the School of Law at the University of Reading. Today, the plan was to talk a little bit about copyright and the creative AI, thinking a little bit about how copyright law considers the outputs of artificial intelligence programs and machine learning platforms. So the plan for today's kind of discussion is I'll give a little bit of an outline about what copyright and intellectual property law is, and then give a little bit of a sense as to how machine learning and artificial intelligence technology challenges copyright law. That's probably the serious part of the discussion. And then we're going to move into a little bit of a slightly tangential talk about sciences and spirit writing. This does connect, though, to artificial intelligence and copyright law. And that is because we have a really interesting case from the early 1900s, the Cummins and Bond case around a book that was written by a spirit. And the way that the court treated the authorship of that book is perhaps really interesting when we start thinking a little bit about how current copyright law should deal with works created by, for example, machine learning tools trained on existing works. So we'll talk a little bit about that, and then we'll see if time permits, we might go and have a little bit of a discussion about some of my own experiments with artificial intelligence generated music, and some of the legal issues around its use. So we'll see how we go for time. So to kick off, I appreciate that not everyone in the room is necessarily a lawyer or has had as much experience with intellectual property law. So as by way of fairly quick and relatively brief introduction, and happy to come back to this in the question, I just wanted to introduce intellectual property law and how it operates. So intellectual property law is a kind of umbrella term for a number of different legal regimes. These include patent law and trademark law that Rajashree will be talking about later today. Broadly though, it's the area of law that deals with what we call creations of the mind. It's a definition from the World Intellectual Property Organization. When we're thinking about what distinguishes intellectual property law from other areas of law, theorists talk about this idea that intellectual property is interesting because we're talking about non-physical property. When we're talking about what's protected by a patent, it's not the actual physical invention, it's to some extent the inventive idea. When we're talking about what's protected by copyright, I'm not talking about protecting a physical book, but I'm talking about protecting a story within that book. So it's non-physical. And the value when we're thinking about intellectual property is based on ideas or connected to ideas. And as I said, lots of different forms of intellectual property. The one that I'm going to focus on in my talk today is copyright, which is the branch of intellectual property law that focuses specifically on expression. I'm going to talk about that because I'm interested in the way that we treat the outputs, the creative outputs of machine learning algorithms or artificial intelligence programs. So copyright is a fascinating area of law and it protects a wide range of things. Here in the UK, copyright law protects literary works, so books, for example, irrespective of their artistic merit. So you might be a huge fan of Twilight and you think it's the best book that's ever written. Good, that's going to be protected by copyright law. But equally, something fairly technical and dry could also be well protected by copyright. So for example, a small engine repair book will also be protected. What's interesting, I think, about copyright is that the law treats computer programs, so the source code, for example, from a computer program, as if it was a book. So it's protected effectively as a literary work. That's, of course, not the only thing that's protected. We also see artwork. So, for example, photography, arguably sculpture protected. Both that Oasis cover art from one of their albums and the Stormtrooper helmet have been interesting litigated cases in this country. We also protect dramatic works like scripts, and we also protect music and sound recordings under copyright. So lots of scope of protection. There are other areas as well, performance, films, all sorts of areas of protection. In terms of the source of copyright law in this country, as a lawyer, we would start by turning to the relevant Act of Parliament. And the most important Act of Parliament for copyright is the UK Copyright Designs and Patents Act 1988. It's been amended since 1988, but it still retains that date. That Act isn't complete in the sense that there is always uncertainties, and when it comes to a piece of statutory legislation, it's very commonly the case that we need to turn to the case law, to the opinions of judges in disputes, to help understand the meaning of that law. So here's a picture of Justice Richard Arnold, who is a really interesting IP judge. There he is looking a little bit less formal. So we see kind of the main areas of copyright law. We're looking to the statute and we're looking to the courts. That's not to say that there aren't other influences. I hesitate to say the B word and Brexit, but at the moment, European Union law, both directives and cases, has a significant influence in the UK. And I suspect it will continue to have a significant influence for a number of years moving forward, given that effectively, when we do finally separate, we're going to crystallize existing European Union law and shove it into the UK system. So European Union law is going to remain of relevance, I think, for a number of years post-Brexit. We're also in a situation in copyright law, and indeed in most forms of intellectual property law, where there is some degree of international harmonization. So the copyright law that we see in the United Kingdom is broadly similar in some senses to the copyright law we see in other jurisdictions. And that's because it's been to some extent harmonized by international treaties like the Berne Convention or by the TRIPS agreement. So there's quite a significant degree of harmonization. In simple terms, if we're thinking about what do you need to get something protected under UK copyright law, there are three main requirements. The first is that whatever that thing is, it needs to fit within one of the categories in Section 1 of the Act. That includes categories like literary, dramatic, musical, and artistic works. You have to have your output, be it a photograph, be it a play, be it a book, fall within one of those categories to be protected. In addition, the work has to be fixed. What we mean by that is that the work has to be written down or recorded electronically in some way. And then finally, and this is probably the most controversial requirement internationally when it comes to AI outputs and AI creativity, is there's a requirement that the work be original. And for other kinds of work, we've had really interesting cases develop this idea of, well, what exactly does it mean for something to be original within the meaning of UK law? So that originality requirement has evolved over the years. If we go back around 100 years, one of the very influential early cases was the University of London Press case, which talked about maths examination papers. And there the court said, look, when we're talking about originality, it's key that we're talking about this idea that the work hasn't been copied from someone else. So it's original in that sense that it's not a copy. Over time, however, the UK courts kind of modified that standard. They continued to say, look, it can't be a copy. You can't just copy someone else's book and pretend that it's your own work and get copyright protection. In addition to that, though, the courts also said we need some level of originality. And the way that they phrased that originality standard was that they looked for some level of labour, skill or judgment in the work. Again, Ladbroke-Hill is an interesting case talking about whether there's labour, skill and judgment in the preparation of betting coupons. More recently, there's been, in 2009, a fairly influential European Union case, the InfoPack case coming out of the Court of Justice, which has talked about this idea that for countries within the European Union, it's important that for something to be original, it must be the author's own intellectual creation. And so there we see originality being linked with authorship. And this idea perhaps of a human author making free and unconstrained creative choices. Now that InfoPack case is a European case, but it has been, its influence has influenced, UK domestic law. So we see UK domestic courts now talking about the author's own intellectual creation originality standard. So that's the very basics of copyright. You know, in order to be protected, you need something to be original. There are special rules, though, in relation to computer-generated works that I'll turn to in a moment. Before I do that, I want to talk very briefly about the AI creative revolution. And I appreciate that I probably have a room full of people who are specialists in AI or in machine learning, and I'm a lawyer and I know the law. So I apologize if I get some of these details wrong. But I just want to give you a sense as to how we've seen in recent years developments in AI creativity. So we're now at a point in terms of machine learning where you can take a corpus of written text. For example, you can take all the works of Shakespeare, you can feed it into a neural network and have that network generate new outputs. So instead of a nice little line from Shakespeare, you could have a neural network or an AI trying to create its own version of Shakespeare. So here on screen is some AI Shakespeare that I generated a few years ago with a very, very simple machine learning tool. It's not bad, but I never liked Shakespeare, and I think this is pretty close to decent Shakespeare. You know, it's not the best piece of poetry, but it's okay. We're also seeing that kind of technology being applied to artwork. So one really interesting project, again from a couple of years ago, involved Microsoft and ING sitting down, scanning all the works of Dutch artist Rembrandt, putting that into a machine learning algorithm and developing what they called the next Rembrandt. So an artistic work generated by machine, which was reminiscent of the style of Rembrandt. So we're seeing real advances in this type of technology and some outputs that, had they been produced by a human, we might have considered them to be creative works capable of being protected under copyright law. And so this is getting really important when we start seeing these works being sold for significant sums of money. So up there on the left-hand part of your screen is a picture named Edmund de Bellamy. And this was an artwork that was auctioned in 2018 by Christie's for, approaching $500,000 US. That's a huge amount of money. And so AI outputs can potentially be valuable. In this particular case, there was real dispute about the kind of the authorship, effectively, of that particular artwork. And so there's really interesting issues that arise. So before we get to what the UK law says, I think it's worthwhile just pausing and thinking about what different options we might have as a society, thinking about how we draft our laws in terms of the authorship of AI works. And effectively, there's a number of different possibilities. Here, I just want to explore some possibilities that either arise in different countries or which academics have thought might be suitable. So the first example is the programmer. If you've got someone who sits down and programs a machine learning algorithm, then maybe we'd think they are a good person to have an ownership of any outputs of that program. A lot of copyright and IP academics are somewhat concerned about that idea, though, given that we are already giving a copyright interest to the programmer. They own the software, they own the code. And so if we also then protect the output of that software, we're kind of giving a double level of protection. Given that one of the reasons we might have copyright law is to provide incentives, we might think we're giving too much incentive, a double incentive. So we think about whether there could be other options. And another option that is often flagged as a possible owner or author of AI works is the user, the person who takes the machine learning algorithm and presses the big generate button to create a new artwork or a new piece of music or a new piece of literature. Now, I've chosen to illustrate that with a picture of a cat because I think one of the challenges here is that very often with these machine learning algorithms, genuinely all you need to do is press a button and a new artistic work will be generated. And it's hard to say that that individual human had much of a kind of creative say in the outputs. And so there's interesting questions about whether we should give that kind of protection to the user of a piece of software. Other ideas that have been suggested are maybe the machines themselves, the AIs themselves should have some kind of protection. There are challenges there, given that we're not in a position where we have super intelligent or strong AI. It's going to be hard to give something which is not a human legal personality and give them legal rights, but it's not impossible. Companies have independent legal personality, ships have independent legal personality. This is a possibility that we could explore. And the final option that's often discussed by academics is that we just give protection to no one, and that the outputs of these AI machines or machine learning algorithms are freely available for everybody to use. And that's somewhat attractive, I suppose. It would mean that I could hang the next Rembrandt picture up on my wall, wouldn't have to pay anyone, and I have a lovely piece of artwork. So that's a desirable approach for some people. When we turn to how the UK law resolves this issue as a matter of law, the UK is quite unusual in that it has a specific provision of the Act that tries to deal with computer-generated works. So not necessarily works generated by artificial intelligence, but those involving computers. So it's very unusual. Only a handful of other countries have this type of provision in their copyright legislation. So our relevant provisions in section 9.3 of the Act, and it says that if you have a literary, dramatic, musical or artistic work which is computer generated, then the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. Now, this is to some extent an unhelpful definition, because who exactly is the person who has made those arrangements necessary for the creation of the work? It doesn't necessarily get us much further. And there's only been really a single case that's explored this issue in any level of depth. And that's the case of Nova Productions and Mazuma. And it concerned a gambling video game called Pocket Money, which I've not had the privilege of playing, but I understand it was basically a skill-based game, somewhat like billiards or pool, but on a computer screen. And so as a user, you would twist a rotary control to move the angle of the cube in the game of pool, press the shoot button, and you try and sink some billiard balls and maybe win some money. The question was, who was the copyright owner of the artistic works that you see? what was interesting there is it was clear that someone had sat down and drawn various elements that made up what was shown to the player. So someone had created an artistic work, which you see there on the left, of the table with nothing on it. Someone had created an artistic work of the pool cue. Someone had created an artistic work which were the individual balls. But there was no identifiable human who brought that all together in what was called the kind of the composite artistic work that you see on the right-hand side of the screen, the image that was shown to the player. And that was because that was dynamically generated, that the player had some degree of control over where the balls would end up. And so there was an interesting question about who owned that copyright in what we call the composite artistic work, that image on the right. The answer from the court was effectively that in this particular case, the programmer had the relevant copyright interest in those composite works. They said that each composite frame, each composite image was a computer-generated work, and the arrangements necessary were made by the programmer, Mr. Jones, because Mr. Jones had sat down in Photoshop and he had created the images that you see on the left-hand side of the screen. And he'd also created the rules of the game that would explain where those images would be put. And on that basis, he was considered to be the person who was the deemed author under Section 9(3) of the Act. What's interesting in the case is they also talked about this idea of player agency. And they said, look, the player in this particular instance is not the author of any artistic work, because the player's input in this particular game was not artistic in nature. The player contributed no skill or labour of an artistic kind. He has undertaken none of the arrangements necessary for the creation of the images. All the player has done is played the game. Now, I think that's probably the right outcome for this particular game, but it's interesting thinking about how these rules in Section 9(3) might apply to games where there is potentially greater artistic freedom. I'm thinking about games like Minecraft, for example, where people take the very basic rules of that game and create quite interesting artistic works. So it's an interesting case, but one that doesn't necessarily resolve completely the question about ownership of computer-generated and therefore works generated through machine learning. When I've been teaching this to my students back at the university in the School of Law, whenever I give those examples of the Shakespearean sonnet that's being generated by machine learning or the next Rembrandt, inevitably a student pipes up and says, well, why shouldn't Shakespeare or Rembrandt, given, why shouldn't they own the work, given that it's inspired by them, it's taking their style, could they be the copyright owners? Now, of course, one of the issues there is that both Shakespeare and Rembrandt are very much dead. And that got me starting over the years to start think a little bit about some of the other areas where the law has dealt with authors who are dead or who have communicated from beyond the grave. That got me really interested in seances and spirit writing. And so I thought this is a little bit of a silly diversion, but an interesting one, I think, where it's worthwhile thinking a little bit about the extent to which seance and spirit writing, and particularly some of the cases that we've had. I'll primarily talk today about UK cases, but there are some really interesting ones in the US as well. But there's interesting questions about how we deal with the authorship of works generated by spirits, by the dead. So I appreciate that you all came for a talk about AI and law. So you may not know much about spiritualism. So a very brief history. Spiritualism as a movement is really inspired by this idea that the dead can talk to us somehow, and the dead have something interesting to say. And it would be fair to say that spiritualism really kicked off with the Fox sisters, some mediums from the United States who kind of in the mid to late 1800s went around claiming that they could communicate with the dead. So they would effectively call out to the spirits and they would just listen, and they'd listen for knocks. When they'd heard those knocks, those were messages from the dead. And they could then ask kind of yes or no questions and communicate with the dead in that way. And they were very successful, very famous. People were really interested in kind of speaking with them and communicating through them with the dead. Knocking is not a particularly efficient communication style. So we saw over time the development of other forms of communication with the dead. So there you see on screen a wager board, a way of communicating with the dead, where again, you'd sit in a quiet room, light some spooky candles. You place your fingers on this little indicator there, and it would spell out messages from the dead. What was really interesting was that particularly in the period around the First and Second World War, people were really interested in communicating with the dead. And the dead had stories to tell. We had a huge number, hundreds of thousands of books written by the dead. So much so, and this is in a 1917 New York Times review of a book called Jap Heron, written by Mark Twain having been dead by 1917 by a number of years, where the review talked about this idea that the wager board seems to have come to stay as a competitor of the typewriter in the production of fiction. So we have huge numbers of these books being written, and that's always a wonderful thing for a lawyer to hear, because whenever there's a huge number of works being created, there is inevitably going to be disputes. And so there's a really interesting dispute that I just want to turn to now. It's a little bit silly, but I think it has lessons for AI and computer-generated works. So the case is Cummins and Bond, and it concerns the book that you see in front of you, The Spirits of Cleophas, which is, I've got a copy in my office. It's terribly dull. It's a story about what it was like in the early years after the death of Jesus in the early Christian church. It was written by Cleophas, who lived at that time, but then communicated as a spiritual medium, through a spiritual medium, by the name of Miss Geraldine Cummins. And so this is a picture of Geraldine. She was quite an interesting woman, allegedly a spy. She competed in the Olympics, did all kinds of crazy things, a journalist, but she was also a medium. And she would communicate with the spirits by kind of going into a darkened room, lighting some candles, and she would go into a trance. So she would place a left hand over her eyes, she'd rest her elbow on the table and hold a pen or pencil in it. And she'd hover that over a sheet of papers. She'd go into a trance and she'd start handwriting. Her pencil would travel over the paper rapidly, producing legible and perfectly intelligible script. She wouldn't pause to dot to dot the I's or cross the T's. It would be fairly flowing script. So what would happen then is that she would write these stories, transcribe these stories, and then one of the other people in the room with her during these seances, Mr. Bond, would take her handwritten notes and would then type them up and share them. And Mr. Bond then went on and tried to have these published effectively as a book. So Mr. Bond tried to get these published, and there was then a dispute between Geraldine and Mr. Bond about who was the author of this particular book. What I think was amazing is that when this case came before the court, Justice Eve made a completely, for a lawyer, quite an interesting judgment, where he considered and actively discussed the possibility that the true author of this work was a spirit who had been dead and buried for some 1900 odd years. Now, it may be that his tongue was slightly in his cheek when he was writing this judgment, but it's an interesting judgment nonetheless. Talked about this idea that maybe there's joint authorship, where both the medium and the dead spirit were the joint authors. Made a decision based on quite interesting jurisdictional matters. Said, look, I have jurisdiction for England, I don't have jurisdiction for the heavens, so I'll only deal with the people before me here in court today. And decided not to grant authorship to the spirit, and instead basically said, look, given the skill, labour and judgment originality standard that was developing by that time, let's say that Ms. Geraldine Cummins, the medium, is the person who should be the author here, given that Geraldine has that particular gift of being able to communicate with the dead. So Geraldine was considered the author. What I think is interesting about this case, though, when we come back to this question, thinking about the InfoPack case that I discussed at the beginning, this idea that in order under European law for there to be copyright, there needs to be the author's own intellectual creation. I think there's interesting questions about whether or not we could take seriously this idea that spirits could be the ones creating these, the originality, the actual skill, labour and judgment. Could the author genuinely be the deceased spirit of Cleophas? Because if we would consider this kind of case again today, and we would apply a modern copyright originality standard, we would really probably, if we followed the judgment closely, we'd be saying, well, actually, the spirit is the one who's making those those kind of creative choices, the author's own intellectual creation comes from the dead, which might mean that we then have to think about whether the dead could have that copyright interest. So what does that mean for machine-generated and AI works? Well, I think that it gives us an interesting perspective. I think if European Union law requires a human author, and indeed there's some suggestion that maybe UK law is a little bit out of line here, then we could think where we've got machine learning algorithms which are mimicking an existing human author that are trained on their body of work, then maybe we could think about that training set and the author of those training materials as perhaps being the person to whom the outputs should be attributed in terms of authorship. Other possibilities and other complexities here, I think there's real issues there if we do grant spirit authorship to the dead, or indeed grant authorship to the authors of inputs to machine learning algorithms, dealing with the overlap with their existing rights. It's not impossible to resolve, and it's certainly something that the law could deal with. The other kind of complexity is calculating how long protection should be. So normally under copyright law, if you write a book, your book will be protected for your lifetime plus 70 years. So we calculate the term of protection under copyright based on the day that you die. And that might be a little bit complicated if we're talking about, well, Shakespeare's been dead for a very long time. How do we calculate that term of protection for a work that's being generated now? There are still potential pathways to protection. And one interesting thing that I think is relevant both for AI works and for spirit works is that it might well be the case that people are dishonest. We sometimes see that in law. And they might falsely claim that they as a human are the author of a work that was either given to them by the spirits or was an output of a machine learning algorithm. And if that's the case, they could falsely claim authorship, or they could publish work anonymously or pseudonymously, and thereby get copyright protection. So even in jurisdictions like the European Union, where it might be difficult to get AI works protected under copyright law, you could, for example, falsely claim that they were the work of a human author and seek protection that way. So it's an area where the law is going to need to pay attention in the coming years. I appreciate that I probably ran slightly over, but I know that we kicked off a little bit early. So I'm going to be really cheeky unless someone cuts off my slide and just give you an example of some of the complexities. I think this is a nice lead into Rajeshree's talk as well. Some of the complexities that I've encountered in producing my own materials, working with machine learning algorithms. So the particular example came up just a few weeks ago. I was asked by the law school to do a taster lecture, put it online, make it a lecture for students who might be thinking about coming to the University of Reading to study. And I thought that I would do it on a particularly interesting UK case called the Lucasfilm and Ainsworth case, which is about the copyright protection for the Stormtrooper helmet, whether that counts as a sculpture under copyright law. And as doing that, I thought, wouldn't it be fun if I had a little bit of theme music to kick off the video? And so I wanted some music that sounded like the main Star Wars theme. So just a couple of seconds of that to jog your memory. And hopefully it's not too loud for you. That's the Star Wars theme that you hopefully all know and love. So I wanted to use that, and the copyright compliance team member at the university said I could use about 20 seconds worth of that, and then otherwise we were worried that Warner would sue us. So I used about 20 seconds and went, well, I still have a bit more background music that I need. What do I do? So what I did was I downloaded a MIDI version of the Star Wars theme. And if you're not familiar with the MIDI file format, I think the best way of thinking about this is it's a file format for music files that is somewhat analogous, I guess, to sheet music. You know, it tells you what the instrument, what instruments are playing and what notes those instruments are playing. But it's not really a recording of a live musician. It's a little bit distinct. So here's a fan-created version, which is effectively a fan has listened or read the score from John Williams and created a MIDI version. So I downloaded this, and I took an 8-second chunk. The Star Wars theme is not performed by live instruments. What I then did was I took that 8-second MIDI chunk and I uploaded it to one of the Google projects, the OpenAI neural network, which is a neural network which listened to that particular output. And then by choosing a couple of elements, the style, the inspiration, I was able to regenerate some music and edit it together into a set of music that sounded not quite like Star Wars, but was Star Wars-esque, that could play as a bit of background music. And so here is, it's pretty awful. There's certainly been better machine learning algorithms for music creation, but this is what I put together in the background. So you hear the Star Wars similarity, and then it starts getting a bit repetitive and going off the rails. So it's not the best musical work ever created, but there's about 30 seconds of that, which I included as background music. So the interesting question that I think we have is, well, is there copyright in that AI generated music track? And if so, who owns it? OpenAI say that they do not own the outputs of their work. And that leads to an interesting question that Rajeshri might touch upon in terms of the impact of contract on this. There are interesting questions about who made the necessary arrangements for that work. Is it John Williams who composed the original work? Is it the fan who created the MIDI version? Is it Google who created this algorithm and a machine learning tool? Is it me, because I was the one who had a bit of a sense as to what I wanted the music to sound like, and I kept on pressing generate until I got something that I wanted? So really interesting and quite open questions. So that's I think a nice little segue to the further talks. Be a bit of an opportunity for questions. I'll flash up on screen just some of the images that I used in some of the sources. And then there's a shameless promotion for the School of Law. The contact details there are for the school if anyone is interested in learning more about studying at the University of Reading.
Brilliant. Thanks, Adrian. That was really interesting. I'm just going to ask one question because I think you've left that a really good point to actually hand over beautifully to Rajeshri. But the questions come through to me about where there is a piece of work where copyright already subsists. Could AI-generated artwork potentially infringe that by recreating an image that uses a substantial part of another work? Could that be considered copying?
Quite possibly, and it's a really difficult issue. One of the interesting things that's being developed in terms of copyright policy making is an exception to permit text and data mining. So often we have these rules about who owns a copyright protected work, and then we have exceptions that say, look, even though this person owns a work, you can use it in certain ways without permission and without payment. So for example, I used a lot of pictures in that presentation. I am not the copyright owner and I haven't paid anyone for it, but that's okay because copyright exceptions let me do that for that teaching purpose. You have similar kind of rules in other jurisdictions. The very famous one is the US fair use exception. But we're thinking a little bit about whether we need to think about the scope of the text and data mining exceptions to allow the use of inputs to train a neural network. And then there are also really interesting questions where it certainly could be the case that the output of a neural network potentially infringes. Google very explicitly states that if you use the AI tool that I used, they do not guarantee that the outputs will be free from copyright infringement. So you live dangerously by generating that work. So it's a live question. If you had a specific example, you'd probably want to, and you didn't want to live too dangerously, you might want to consult a lawyer because I think there's a lot of interesting scope for that to be infringing.
Brilliant. Thanks ever so much, Adrian. So I think it's a good time to hand over to Rajeshri.
Thanks very much, Sarah. And I think Georgia's going to put up our slides. So thanks very much, Georgia. So the reason I say that Georgia is going to put up our slides is because Georgia and I are on the same team at HCR Law. And I'm going to be talking today, and Georgia's going to pick up one of the last slides at the end to finish off for us. I wanted to start off today talking a little bit about artificial intelligence, what it is, some hopefully interesting definitions, and some landmark moments in its development. And then I'm going to outline what intellectual property rights are going to be most relevant to its protection and the key principles of how those operate. Now, Adrian's already talked a fair bit, of course, about copyright. So I will probably be focusing more on patents, although I'll touch on and build on some of the copyright issues as well. We're then going to be talking about what is becoming known as the creator or inventor debate, again, building a little bit on what Adrian talked about and looking at it from an English legal framework perspective, but also from a business perspective. We're then going to pause for a quick look at some of the considerations you'll want to look at as the owner of an AI business or any IP-rich business for that matter. And hopefully that will be of some interest to the business owners and founders amongst you. And then finally, in a way, taking what Adrian's been talking about and what I'll be talking about and sort of throwing it into the big global policy discussion picture, my colleague Georgia is going to talk a little bit about some of the strategy and policy debates that are going on at governmental and world intellectual property organization level, but I'll leave her to do that at the end. So what is AI? In 1956, the term artificial intelligence was actually coined at a Dartmouth College summer conference. That's Dartmouth College in New Hampshire in the US. And AI was effectively founded as an academic discipline. The starting point for the conference was, and to quote, to proceed on the basis that every aspect of learning or any feature of intelligence can in principle be so precisely described that a machine can be made to simulate it. Since then, there have been a number of artificial intelligence milestones, which many of you will remember if you're as old as I am, or be aware of at least, and which are worthy of note. So just to go through some interesting milestones, hopefully you'll find them interesting. In 1997, Garry Kasparov, the world chess champion at the time, was beaten by the IBM supercomputer Deep Blue. In 2002, the first household robot was produced, the vacuum cleaner called Roomba. Same year, Amazon started to use automated systems to provide product recommendations on its websites. And in 2008, Google pioneered so-called neural networks, which Adrian was talking about, introduced speech recognition in their apps. And in 2010, Microsoft launched Kinect, that's with a K, in their games, which tracks human body movement. Since 2012, there have been great advances, as all of you will know, in autonomous vehicles. And of course, there's been the growth in big data, which has supported the development of more and more advances in AI. Big data providing what is known as the training data for AI, and Georgia will pick up on that later when she talks about the policy discussions that are ongoing at the World Intellectual Property Organizations. And then the final example I wanted to give you was a couple of examples. DeepMind, the music generation AI tool, which obviously links into what the demonstration Adrian gave you. And we know about the 2016 Next Rembrandt project that Adrian also mentioned, in which a group of Netherlands museums and researchers unveiled a portrait of that title, entirely computer generated, that had analysed the works of the artist to get there. Today, there's no universal definition of AI, but generally it's agreed to be a discipline of computer science aimed at developing machines and systems to carry out tasks considered to require human intelligence. And a couple of other interesting definitions. Merriam-Webster calls it a branch of computer science dealing with a simulation of intelligent behavior in computers, or the capability of a machine to imitate intelligent human behavior. And the Cambridge Online Dictionary sets out an interesting definition: the study of how to produce machines that have some of the qualities that the human mind has, such as the ability to understand language, to recognize pictures, to solve problems, and to learn. Now, from a legal perspective, it's interesting or helpful to see AI as essentially advanced software, and even in some cases, software that writes itself. So moving on to key IP rights, which are going to be relevant in the protection of AI. Before we break them down, as a general principle, and as Adrian touched on, intellectual property rights encourage innovation by giving legal protection to what we might call creations of the mind, by which we mean inventions, artistic or literary works and designs. And there are several other subcategorizations in the relevant legislation that governs IP. IP rights enable the creators to be recognized for their innovation, and it gives them, in many cases, exclusive rights, at least for a period of time, that allow them to commercialize their work. That's obviously important in the world of tech businesses. So AI is really innovative software, and the interaction between AI and the current legal framework of IP rights available has in recent years been the subject of much discussion and debate, as we've seen, in amongst international and national IP authorities and organizations, amongst academics and lawyers practicing in the field. So the most relevant IP rights are likely to be, not the only ones, but for the purposes of time today and having to home in on specific issues in this potentially very wide-ranging subject, we're going to focus on copyright and patents. And I'm only going to touch on some aspects of copyright because Adrian's done such a great job of giving us an excellent overview there. And I will home in on patents more. But just on copyright, Adrian's already talked about what copyright covers, what kind of works it covers. And one of the key points for our discussion today is that it protects the documented version, the expression of the source code of that of software. Also algorithms, not their output, not the output of their computations, but the documented code itself, and combinations of data sets. And then perhaps combined with hardware or other devices, which together produce certain results. So in the context of AI, the fact that copyright protection protects computer code, software code, is clearly a key factor. Adrian's talked about where copyright arises in terms of what works it covers, but I just wanted to touch on, and it'll become relevant in a further discussion we're going to have of copyright and intellectual property rights in a business context. I just wanted to touch on some of the principles that apply to copyright, how it arises, how it works in the UK. So it arises on the creation of a work, product, and it's owned by the creator, be that an individual or a company as things stand. And for company, we include where the work is created by employees in the course of their employment with a company. So any work product that I produce in the context of my employment with HCR, the copyright in that work belongs to my employer. Copyright gives the owner an exclusive right to make copies and distribute the work product, and other rights of exploitation, such as licensing. There's no copyright registration system in the UK, so care needs to be taken, again, particularly in a business context, which is where we come across these issues all the time, to keep a track of when and how key copyright works are created, and documentation and good record keeping is therefore going to be key. And I'll touch more on this later, and the pitfalls to look out for if this is actually not done properly when an IP-based business is thinking of seeking investment or selling. So we'll come on to the implications of these general copyright principles for AI works, although Adrian has covered some of that ground. But before we do, let's look at the second type of intellectual property right that I'm going to focus on, which is patents, particularly relevant to the sector as well. So, brief overview, patent is a registered right to protect inventions. It must be applied for, and if granted, in the UK at least, it gives a 20-year exclusivity to exploit the invention which is protected. Key elements that need to be demonstrated for patent protection to be a possible option are that the invention must be novel and involve an inventive step. So that's all assessed against the pre-existing knowledge in the relevant field and what is known as prior art in the patent world. And crucially, the invention must be capable of some sort of industrial application. It's important to note for software and IT businesses in particular that the UK approach to the patenting of software or business or mathematical methods in themselves is more restrictive than the wider EU approach, and yet more so than the US approach. So in the UK, as the law currently stands, you're not going to be able to secure a patent for a computer program as such, or a pure mathematical formulation, but you might be able to get a patent for a wider product or system that is run on software. In terms of patenting artificial intelligence inventions, there's been a significant growth in the number of AI-related patents applied for in recent years. There's been a 400% increase in the number of published AI patent applications globally in the last decade. Before we move on to the interrelationship between these IP rights and AI, again, particularly I'll focus on patents, I just wanted to give you an example of what a successful patent of AI would look like. So the one we've chosen is a product called AlphaGo, created by DeepMind Technologies. And that was a UK-based AI company, many of you will obviously know about it, founded in 2010 and bought by Google in 2014 for £400 million. So why did Google consider it so valuable? Because the DeepMind group developed machine learning AI technologies that relate to the architecture of neural network software, enabling deep machine learning. DeepMind ended up pursuing patents in text-to-speech systems, machine translation and speech recognition, in image processing and image classification. And that's what Google recognized as the highly valuable asset to be used in technology across many industries. In fact, machine learning is the dominant AI technique disclosed in patents, that forms the basis of patents. It's the fastest growing AI technique for patent filings. And that's typically the technology that's used in text, voice or image recognition, spam filters or machine translations. So Georgia's just going to move on to our next slide. And you'll see there we've called this the creator or inventor debate. And here we want to talk about the interrelationship between the IP rights we've been talking about, both Adrian and I have been talking about, and AI, and how the two link together. So just to make a general point, again, about IP and what its purpose is, IP systems have been developed, the IP framework has been developed to protect human invention and creative processes. Say the writing of a novel or music, the design of engineering parts, or the design of a creation of distinctive product or brand name even. And over the years of development of software and technology, copyright has been extended to apply to it. New rights, such as the database right, have been developed, and patents have been able to cover software processes or systems. As we've started to see from Adrian's talk, AI represents a new challenge for the current intellectual property framework that we have. In recent years, AI systems have matured enough to take on tasks previously performed by and associated with humans only, and not only pre-programmed tasks, but artistic or other creative endeavors. So let's take that next Rembrandt project, for instance, the 2016 project. As we said, the project created a so-called new Rembrandt painting based on lots of data compiled from Rembrandt's body of work. It was intended to fuel the conversation about the relationship between art and algorithms, or between data and human design. And it raised several questions. Who is the creator of this computer-generated result of analysing data from Rembrandt's body of work? Can a programmer be considered an artist? Who, if not the computer or the AI, was the creator of this new masterpiece? So in the creator or inventor debate, as we continue to think about the relationship between IP rights and AI, we can look at copyright and patent separately. I don't want to spend too long on copyright because, as I say, Adrian has really covered that in a very interesting way. And he talked about the ways in which copyright protection can be approached, either to deny machine-generated works copyright protection altogether, or look at making a decision about who the author might be in those circumstances. We've talked about the fact that the UK law has a specific provision for computer-generated work, and effectively gives the authorship, the copyright ownership, to the person responsible for making the arrangements for creating that computer-generated work. And the idea behind that provision is to create an exception to human authorship requirements by recognizing the work that goes into creating the program capable of generating work. As far as we can tell, conferring copyright protection to works generated by artificial intelligence has not been specifically prohibited anywhere. But there are definitely indications that the laws of many countries are not going to be especially open to the creator of copyright not being human. So the US Copyright Office has stated that it will register an original work of authorship provided that the work was created by a human being. And that arises out of US case law that specifies that copyright law only protects the fruits of intellectual labor that are, to quote the case, founded in the creative powers of the mind. So having touched on copyright a bit there, and not to cover ground that Adrian's already covered, I wanted to look at the relationship between patents and AI. So there's more than one approach that can be taken when discussing AI and patents. One is that where inventions make use of AI, so for example, in controlling a piece of machinery, then the patent system works reasonably well to allow those sorts of invention to be protected in the usual way, with the usual caveats that protecting a purely computer-related invention can be difficult. The other area is more complex, and that is where artificial intelligence is used in the development or creation of the invention itself. So moving on to the next slide, this is where the recent DABUS decisions come into play. DABUS being the name of the AI-based computer that made the invention in this particular scenario. So these were legal cases. As background, in a patent application, there's a requirement that the inventor has to be identified. If the inventor, and I'm talking about an individual inventor here, it's possible for a company or business, to a particular legal entity, to be the owner of the patent, but the individual inventor also needs to be identified on a patent application. So yes, if the inventor is not identified, the patent application is going to fail. In the DABUS cases, as the invention was made by a computer, the applicant for the patent attempted to identify the computer as the inventor in order to satisfy the requirement that the inventor be identified on the application. The decision that was made by the UK Intellectual Property Office and the European Patent Office in considering whether this patent application could go through, the decision concerns whether a computer can be identified as the inventor. And the approach that both the UK and European patent offices took is effectively to say that the inventor has to be a human inventor, and so Dabus could not be regarded as the inventor, as there was no human inventor and one couldn't be identified for the patent applications. The applications were refused. And the US Patent Office has taken a similar line. So it's something we need to watch this space for, actually, because those patent decisions are currently under appeal. So we'll certainly be keeping a track of what happens there. It'd be really interesting to see how that pans out. So going back to our previous slides where we were listing our general principles about the general questions about the creator and inventor question, there are all sorts of questions ongoing about whether the decision in that Dabus case is fair and whether the patent system needs to be tweaked to, for example, remove that requirement to identify the individual inventor, or to allow a non-human to be identified as an inventor, very much parallel to the choices that Adrian was talking about in the copyright context. However, there's been no decision on this, and so the current position is that naming a computer as an inventor on a patent application is not permitted. It's worth dwelling on this a little longer, just to say that actually there are some practical issues that still arise even if you solved that debate. So even if, for whatever reason of policy or legal decisions of those patent office decisions, even if you allowed that AI inventor to be the named inventor, there are other issues that arise. So even if that's resolved, it's more complex, because the identity of the inventor can determine who is the ultimate owner of the patent rights. So remember I said that you could have an owner of patent rights with an inventor listed. So the owner could be a company and the inventor would be the individual person that came up with the invention in the first place. So where the inventor is not employed in a role in which he or she would be expected to make inventions, it's not part of the usual course of their employed work, then the inventor, that individual inventor, would be the owner of the patent rights. Where they're employed, then the Patent Act, the UK Patents Act, sets out that in many situations, the employer will be the owner of the rights. Where an invention is made by a computer, then it's unclear who would own the rights. The computer would not normally be regarded as capable of owning the rights, as we've seen. Equally, even if it were recognized as an inventor, it's not employed. And so an employer would not own the rights in the same way that the employer would own the rights that an individual inventor came up with. Unlike copyright, where there are provisions regarding ownership of computer-generated works that Adrian talked about, the UK Patents Act is silent on this subject. So as well as addressing the issue of whether a computer can be identified as the inventor, the issue of who owns computer-created inventions needs to be addressed in the patent field. And that's all up in the air at the moment. Until those issues are resolved, inventors and businesses involved in the creation of AI-generated technologies are going to need to consider what practical workarounds are available. Obviously, one could simply seek not to protect computer-generated inventions, but this could lead to businesses being unable to protect important computer-generated ideas. And it could discourage innovation and even investment in innovation. Remember, we said that patents give the owner exclusive rights for a period of time to exploit and commercialize the invention in question. And so if you can't secure those exclusive rights and get a competitive edge in the market, then would that discourage the innovation in the first place and the investment it requires? Going back to practical workarounds, where an invention is genuinely made in part by AI and in part by a human, then it's possible that by drafting a patent in a way that the claims or the specifications of the invention that you need to include in a patent application, such a way that those specifications capture the human developed part, then a workaround may be just to name the human as the inventor. That would allow the requirements to identify the inventor to be met and would help with addressing ownership. But where the invention was conceived solely by artificial intelligence, there are real difficulties with no clear solutions to the problem, as we've seen. And simply nominating an individual as the inventor on a patent application when he or she had no inventive input could lead to the patent rights being invalid, especially in the US as things stand. Next slide, please, Georgia. So we've been talking about IP rights in artificial intelligence, and I'll be handing over to Georgia shortly to give you a flavour of the policy discussions that are currently in progress at the World Intellectual Property Organization. But before I do that, because I know that there were likely to be owners and business owners and founders amongst you, I wanted to pause to highlight a few points around the purpose of paying attention to IP protection in a business context, and partly because this is my real area of expertise, and that is to advise businesses who are in the tech sector, the AI sector specifically, and on a daily basis, we're advising on the protection of IP rights. And where this comes up on a regular basis is where particularly growing tech businesses are preparing for new rounds of investment, they're seeking investment, or they're even preparing for a sale, having got to a certain point of growth and success that they're attractive to a buyer. And the preparation of an AI or any tech or IP-rich business for investment or sale really underlines how important protecting your IP becomes. So the purpose of IP rights in this sphere is, of course, to protect rights in the relevant technologies that you're engaged in, and to be able to be in the best position to commercialize them as a business. For instance, by licensing for use and exploitation that IP to one licensee in one field of use and to another in another field of use, and earning the various revenue streams that both of those licensing streams generate, or to reserve the IP rights for exclusive use and gain some competitive edge in the market in commercializing those rights. And there can be a host of IP rights in one AI invention, for instance, and those can be split and shared in commercialization if clear lines are drawn in appropriate contractual arrangements as to who has the right to exploit what, how, where, and for how long. So as an AI or tech business, your IP rights are likely to be the most valuable business asset that you have. So when as an IP business, IP-based business or IP-rich business, you're growing and looking to secure new rounds of investment or even sell, your investor will want to know if the business owns or has the legitimate right to use the identified IP assets that go to the very value of the business. And they'll be investigating those issues in the process of what they will call their due diligence exercise into the business. And before I hand over to Georgia for the policy discussion, I just wanted to give you a little illustration as to why this is so important. So a colleague in my corporate transactional team recently advised on transaction and talked to me about it. And it was a software solution, was the main asset of the business that we were advising and who was selling. And it transpired that at various times throughout the growth of this business and the development of the software solution that formed its main asset, tens of consultants were contracted in by the company at various times in that growth journey. They weren't employees, but they were independent consultants or contractors who were brought in to advise and consult on the piecing together of the software solution. They wrote code, different consultants wrote different pieces of code, they wrote algorithms, and they were paid for their work by the company. But it turned out, when it came to us looking at this project to advise our clients on the sale, that all of that work that the consultants had done, the programming, the coding, the IP rights didn't belong to the company. So we've got this software solution at the center of the company's value, and they don't own the IP rights. So how did that come about? Well, let's apply some of the IP rights principles that we've been talking about. In this case, copyright was the key intellectual property right. We've talked about how it's copyright which will protect the source code for the software. It comes into being on creation of the work product. So in this case, when the relevant pieces of source code were written, and it's owned by its creator. The creators here were these independent contractors. They weren't employees of the company, so the employer didn't by default own the rights. Copyright can only be transferred to another person or company if the creator transfers it by way of a written signed contract. And that's often called an intellectual property or copyright assignment in this context. So the company, in this case, had to track down all these consultants, have them sign assignment documents, transferring any IP rights that they owned by default on their creation of the software to the company so that the IP asset ended up within the entity where it was initially intended to be. And of course, we can see in that scenario the potential here for a bad actor, consultant or contractor, being in a position to effectively hold the company to hostage in respect of rights that went to the fundamental value of the business, and how this particular business sale could have actually fallen apart if all the rights were not agreed to be transferred by these consultants. How could the company have avoided this? Well, the answer is to have ensured that all of those consultants and contractors signed up intellectual property assignment documents prior to their starting the work, or as soon as possible thereafter, to pick up rights they've created in the past and rights they might create in the future. Now, there are lots of other considerations for an IP-rich business to consider in the context of preparing for an investment or sale to ensure that an investor or buyer can see that IP rights have been properly identified, protected, and are secure for use going forward. My illustration here is just intended to highlight the importance of a business understanding how its IP is created and properly managed. So that said, we want to return to conclude now our discussion of IP rights in AI. And in doing so, I'm going to hand over to my colleague, Georgia Schreien, who's a senior associate in my team in the Thames Valley office of HCR. And she's going to spend the final few minutes highlighting some of the policy and strategic issues currently being discussed in the World Intellectual Property Organization, or WIPO, as you might hear her refer to it. And that's a self-funded organization of the United Nations and will undoubtedly drive, or at least very heavily influence, IP policy as it relates to AI across many countries. So I'll hand over to Georgia.
Thank you. So we all know that artificial intelligence is a big subject, and I can tell you that so is intellectual property law. So I'm going to keep this discussion now on policy short and fairly light for the last 5 minutes or so of this webinar. There are essentially two main areas of discussion on AI policy that I want to touch on. The first is are the general national policies on AI, with countries and territories competing against each other to conduct research and development into AI. AI is recognized now as a general purpose technology with widespread application, and there is ever more data available to provide excellent training materials for AI applications. So in the UK, the government policy is dedicated to advancing and supporting the development of AI. They estimate that the AI sector will add 630 billion to the UK economy by 2035, and therefore AI policy is very much part of this government's industrial strategy now. If we look to the EU, their approach to AI policy is just as ambitious. They, though, in general have the protection of the European citizens and their human rights very much at the heart of their policy. There's great emphasis on ethical AI and responsible development of AI, always ensuring that human rights and human safety is a priority. One of the concerns that the EU have going forward is how the governance of AI research will work, how to put in place appropriate boundaries for AI development without actually killing research. It would be too much to say perhaps that research and development into AI in the US is entirely unfettered, but it's definitely less restricted. Their policy guidance is invested, well, first of all, the investments there are huge, and their guidance calls for respect of human rights and an emphasis on ethical development of AI. But their focus really is on national security and the AI race to be at the forefront of research and very much competing with China, and that is really their aim. So this emphasis on the development of AI across the world really, and its forecast exponential growth, brings me to the second area that I want to talk about, which is the policy of IP in connection with AI. And we've already heard really from Rajeshri on a couple of points and from Adrian. So just to sort of recap what we've heard along the themes there is that our IP frameworks currently cover very much the human inventions, and AI, along with other software, is covered at the moment, but as a human invention. It is deemed not to be an inventor itself, either by copyright or, if it satisfies the novelty test, even by patent. There's ongoing debate now whether there is a real need to change the legal frameworks and systems and for intellectual property rights to recognize AI as the inventor, both the author in copyright or the inventor of a patent. And the solution that Adrian touched on, and I think Rajeshri as well, that you name the human sort of most involved in the AI invention as the inventor has been a practical solution to date. It has occurred a number of times. We know that AI has been generating novel inventions of its own effectively for some time. There's been no success in putting through those 2 patent applications recently. It has gone to appeal, and I think there is an appetite now for some change in those legal systems. As it stands at the moment, though, all countries register only human creators inventors. It is, though, important to note that no countries have actually ruled out the possibility of AI as an inventor in the future. We just don't have those laws in place yet. And it's against that background, really, that the WIPO policy now has been looking at that as part of its conversation on IP and AI. Very recently, literally last week, I think it finished on Friday, there was a COVID-safe version of the WIPO conversation online, 3 days of 2 hours of conversations. The webcast is now online. There's been no official report issued yet. And they have issued a list of what they consider to be the main policy areas and the main points for discussion. And that list is long, and there are many different areas of policy that they're looking at. So I have had a little look through that, and I've picked some of my favorite ideas out of it. For example, one is, we've already talked a little bit about the need for novelty in a patent application, and that novelty is usually judged as being a non-obvious inventive step, and the measure of what is obvious, because it's so far always been human, would be a person who is skilled in that area. So if we're now going to look at possibly recognizing AI as the generator and the inventor of novel work, how are we going to apply this novelty measure, a non-obvious inventive step, but who is the measure against whom we assess whether it's obvious? Do we ask an AI application that is trained with specific data from a designated field? It's a new measure that we would have to introduce, and it seems unlikely that a human can continue to be that decider. Another question that is really coming up in the WIPO discussions is the use of data in AI. Because data is the main ingredient in training AI, there is a question as to how that data should be protected. And again, Adrian touched on that in his talk. At the moment, we are not quite clear on this. So we have the idea that data that might be subsist in a copyright work can be used as training data for AI purposes, and it may or it may not infringe copyright. We're not entirely sure about this, and this is one of the topics for policy discussion. Should it constitute copyright infringement, or should there be a new exception introduced to say that, well, no, if you're going to use this copyright that subsists, but only for the purposes of training AI, then that's an exception, an exceptional use. There is then also the argument around ethics in AI that comes back to the use of training data and the choices that we make in selecting that data, and the governance of how we select data to train AI. We've already seen some real world problems that come from the data used in the facial recognition AI, where the data that's been used hasn't been carefully enough selected effectively and had the biases that then led to various effectively almost racial discrimination, or certainly arrests for some people without any foundation because the facial recognition was not good enough. When we then look at the opportunities for deep fake technology, this is again something that the WIPO are looking at, how deep fake technology could be managed. Should it be banned entirely, or is there really a useful application for it to be exploited by popular performers, for example, after their deaths, even were they to consent to that, obviously? And if we had deep fake footage, which would be based on obviously data of that performer, if we had deep fake footage that resulted in a recording, obviously, would that be covered by copyright, and to which part of it would it attach? Would it attach to the data used to train the AI to create the deep fake technology, or would it be in that bit of deep fake footage effectively? And then who would own that copyright? Would it be the author of the deep fake footage, which would be the AI technology, or would it be the selector of the data, or could it even be the original performer somehow? So these are all really interesting policy questions that are difficult to answer, and this is why there is this discussion ongoing. The WIPO has finished really on their list of issues to be discussed with a tricky question as well, which is it even too early for us to be considering all these policies, given that we're going to have exponential growth of AI technology, and at the moment we don't really know how that's going to develop. I think actually personally we should be looking at filling this gap and always be prepared to revisit it. So this policy discussion and reviewing the law in this area is absolutely necessary with the growth that we foresee. So to finish with a couple of take-home messages from me. One is, if you're interested in the WIPO discussions, you should have a little look at the webcam footage that they have posted on their website. And two is that if you have software and AI as a valuable business asset, you should certainly be looking at protecting it. Thank you.
Thank you, Georgia and Rajeshri. I've got some questions here for you. So the first question was to Rajeshri. We're interested to know your thoughts around the growth of open source technology. Do you think there could be a growing movement towards open source tech over patents? And actually, Adrian replied, sorry, to this, which is as part of this panel discussion. And he said that was a very interesting question. It's been interesting seeing the ways in which COVID has encouraged broader sharing of medical research. And I do wonder if that might trigger further reflection to the future on the desirability of open source approaches. So do you have any response to that, Rajeshri or Georgia?
Yeah, well, it's interesting because obviously the spirit of open source is open sharing, and you know, one of the things that Adrian said was interesting, and I immediately thought when he said it, yes, from one perspective, that's a good idea, but from the perspective, a lot of the business clients in the IP-rich businesses that I deal with, they wouldn't think so. And that's where we'll have our academic versus business lawyer debates later over a coffee. But what he said was that, you know, one approach to the solving the debate of whether copyright should be conferred on a machine-generated work would be just to not grant it coverage at all and make it freely available. Is interesting in the context of your question, Sarah, because we have a lot of tech business clients who might well use open source technology, and I think it is increasingly being used as the foundation or as the foundation pieces of a larger system or solution that they're building. And on one level, it might sound quite simple, it's freely available technology, but what they have to remember is that open source software still has licensing terms attached and different levels of licensing terms depending on what model it fits into. So it might be as simple as, you know, the original licensor says, every time you license on this open source software, you can make it freely available, but you have to include certain notices or attributions in the chain of licensing on. But more seriously than that, some of those open source licenses, and they're known as the restrictive licenses or copyleft licenses, I guess the opposite of copyright, which mean that if you combine your open source software with a larger invention or solution, unless it's very clearly separable, that open source piece, the license terms under which it is allowed to be distributed effectively mean that the business's proprietary software that has been built on top of that open source piece also gets polluted by the free for use terms, and effectively means that suddenly this proprietary software that you think is the essence of your business and your key business asset has suddenly become freely available. And we've had a couple of close calls there where people have, again, it's normally at a sale or next round of investment that a tech business comes to us. And we're looking at all of their IP assets and making sure everything is order. And we've hit on this problem. We said, oh, actually, that piece of open source you used, that's a bit of a problem. And there've often been situations where the business has had to then do workarounds or redesign that piece, because if they include it in their ongoing licensing model, their proprietary software is going to become freely available. It's a really interesting question. I have seen it used more and more. The issues have risen more and more, but there needs to just be a little bit of care taken even around open source licensing terms.
Thank you. Another question here says that given that there is a requirement for full disclosure of an invention to obtain patent protection, would trade secret protection be more appropriate? Adrian replied to that saying, I do wonder if it might trigger further reflection into the future on the desirability of open source approaches. Oh, no, sorry, that's the other bit. Sorry. I suspect that trade secret protection for software gets easier as we increasingly move to a cloud software as a service instead of distributed software that might be reverse engineered. I think it's an interesting question to consider on a case-by-case basis, taking into account the potential cost of patent protection in multiple jurisdictions. Would you have anything additional to add to that?
Just to add to that, again, piece of advice we give people every single day of the week practically, as you said, Sarah, once you've applied for a patent, all of that information relating to that patent is on public record. But the flip side of that is that if it's already on public record before you apply for the patent, because part of the point of a patent is that it's got to be novel and involve an inventive step, and it's essentially not information or a problem-solving solution that's out there in the field, known to experts in the field or people who are skilled in the field before, something that we're very often advising clients who have potentially patentable inventions is they might be looking into patentability, but then they're often discussing their ideas with investors, with collaborators, with manufacturers, and they've got to have non-disclosure agreements in place with those people in those early stage discussions, because they could find themselves when they come to make their patent application is that they've disseminated the knowledge out there, and you go to get the patent application, you can't get it because it's no longer a novel, inventive invention.
Thanks. And there's a question that I had, which was around separate discussion today, but more about the use of AI within law firms themselves. So is that something that's being taken up, for example, you know, mining for case law or looking through contract clauses? Is there much more technology being used within law firms nowadays, or is that still quite early stages?
So I think it's definitely being used in some of the larger city firms, for instance, and the larger US firms. We have people, in fact, just had an email exchange with the partners in my group earlier this week. We have people and developers of this technology approaching us and approaching our IT team on a regular basis. One of the things that a lot of law firms are looking into, and some already have in place, are, and of course this is something that will potentially put some of us out of jobs, so we want to be careful about that, but is something which in those, particularly in those, what we call those big due diligence exercises that we have to do on a company merger or acquisition, purchase or sale, where you're looking at potentially hundreds of documents. There's definitely technology now actually that is quite well thought of, which does those initial contract reviews and picks out common themes. Personally, I haven't used it. I'd be very interested to see what it produces and how it deals with some of the subtleties. But I guess it's not designed necessarily to deal with subtleties. But of course, the thing about AI is that it learns from patterns and learns from past experience, if you like. So maybe it will learn the subtleties eventually, and will all be dispensable.
Well, hopefully not. And then there was a question that occurred to me when you were talking about the inventorship and ownership side of things. So AI has been used a lot more now, particularly with the medical fields and the medical field. And if AI was used, say, to diagnose something and it turned out to be wrong, could there potentially be some legal ramifications and implications on that? That's probably quite a big question.
Yeah, so I think that's one for the World Intellectual Property Organization at policy level. But no, it's a really interesting question, Sarah. Adrian, I don't know if you have any thoughts on that, but just as the inventor-creator debate hasn't been solved, you've raised something really crucial, which is even if we solve that question, if an invention is based on exploiting a particular patent, and we as a society decide that that patent's inventor and owner is an artificial intelligence machine, then when it goes wrong, who's liable? So I suspect the answer in practice, Sarah, will be that actually liability attaches in a supply chain to all sorts of people down the chain. So the people that are going to be looked to for liability are going to be anyone who is involved. So if you take product liability law, for instance, it's not just the creator of the product or the person who came up with the idea that would be liable, it's the distributor, the manufacturer potentially. So anyone who is involved in getting that product to the market. It's a really, really interesting question, but it absolutely ties in with what we were talking about before. Once you have a machine creator, how do they take responsibility? And then Adrian can answer how those inventions or creations that get attributed to the dead authors, how they take responsibilities on that.
Yeah, I don't know how the dead would be viable in a financial sense. It's a very interesting question. I mean, I think one area where we might start to get some initial answers, thinking about that kind of liability question, is as we see further development in terms of autonomous vehicles. So, you know, once we get to the stage where we are having the vehicles drive themselves completely, and we start getting to a point where it's hands-off driving and you can sit in the back seat and have a coffee, then I think as we start to see fatal accidents or vehicle injuries, then there are going to be some really interesting questions in that kind of liability space. Around, you know, is it the person who owned the vehicle? Is it the software developer who wrote the code? Is it the dealership that sold the car? Is it the car manufacturer? And I think that's a really interesting product liability question.
Yeah.
Well, I think we're almost out of time now. Adrian, Georgia, Rajeshri, have you got any sort of closing remarks or take-home messages that you'd like to say?
I can jump in first if you'd
sure,
like.
Adrian,
just
go ahead.
say, there's lots of fun. If you've got follow-up questions, Twitter and email are fine. I'll pop them in the chat. I'd be delighted to hear from you if you had anything that you further. And happy also to chat to anyone who's interested in doing an undergraduate or postgraduate degree in law. Happy to have a chat about what the University of Reading offers.
Thanks.
Yeah, and all I would add to that is that, you know, and I'm sure Adrian would agree, that there was, when I was preparing for this talk, when George and I were preparing that, and Adrian and I talked in the lead up, I mean, it's such a vast subject, and there are so many angles that we could have talked about. In some ways, we've only skimmed the surface, but hopefully we've highlighted some of the issues. One of the things that I hope comes out of even the subject matter that we've covered, it's a very fast developing area. There's going to be changes at policy level. There's going to be changes, we hope, at legal level. So it's definitely a space that we're watching and we'll be updating our clients and networks on. But in the meantime, I think one of the things that I'd like to, one of my takeaway messages is if you are an IP-rich business, if your business depends on intellectual property assets, remember those are your most valuable assets, and you need to look at how to protect them. In terms of reaching out to us, Sarah will have our email addresses. We're happy for anyone who's participated today to contact us and follow up for further discussion on the subject.
Brilliant. Thank you all. So I just wanted to thank our speakers. Thank you all very much for coming. I found this really, really interesting. It's something I hadn't really considered before, the ownership of works created by AI, and it's certainly something given a lot of food for thought. So just to highlight some of our forthcoming events on AI and healthcare, around data science, new career for you, and our R&D grant funding. Please do sign up there, and I hope we'll see you all there. And I'll leave you with our contact details on the screen. So thank you very much, and hopefully see you soon.